My name is Jeff Morgan. I'm from Dallas, Texas. This is Friday, October the 18th. I'm home from work, and I'm home as well from day 4 of the Save James trial. And even though I thought I understood the importance of this trial and what was going on, it was today that it actually hit me with the full horror of what is happening here. So at stake really is this: should a man be forced to accept the gender, the so-called gender of a male boy? And if not, should he be ordered to do so by the court? Should the court make him, order him to accept the new supposed gender of the boy, or perhaps sanction him, such as by limiting his visitation, or forbidding him from cutting the hair of his child, or not allowing him to talk with people about his son James? James, by the way, is a boy, and James is his legal name. He is a twin brother called Jude, who likewise is a boy. When I saw the documents that were presented before the court both yesterday and today, it became apparently clear to me that James, who is a 7-year-old boy, he cannot make any decisions regarding tattoos, regarding cigarettes, regarding alcohol. He cannot do any of these things because he does not have the ability to do that. This is where a parent should protect a child, is somehow allowed to express his desire so that he is presented as a woman. The implications of this are staggering. I'm going to go back to some of the pleadings that I saw today, and these are available at savejames.com. I will be including part of these as screenshots. So this is a case that is being held in the 255th District Court in Dallas, Texas. The parties are Ann Georgelis. She is the petitioner. She is a pediatrician out of Coppell, Texas. The respondent to this case, this lawsuit, is Jeffrey Damon Younger. He is the father of both James and Jude. Interesting, in this order, it says jurisdiction. The court has continuing exclusive jurisdiction in this suit. And this is the part that is completely frightening to me when you see what the court is going to be ordering. Somehow, due to a divorce, often against one person's wishes, or an annulment, the same thing, often against one person's wishes, the state and the court somehow thinks that now they have the ability to meddle in the internal affairs of a family and to meddle in parenting decisions. This is absolutely horrifying in my mind. So the modification, this is the modification order, and the reason for the modification order is because Luna. Now, Luna is the name that Dr. Ann Georgelis has given to James. James is his legal name, and he is a male boy, 7 years old. At the time, I believe he was 6 when this was done. So Luna, specifically, Luna is a gender expansive or transgender child, and by choice. Now remember, at this time, I'm not sure if he's 6 or 7, by choice, by his choice, the boy who cannot get a tattoo on his own, cannot choose to smoke cigarettes, cannot go into an X-rated movie if he wants to, but by his own choice, he can express the wish that he wants to present himself as a female. He now goes by the name Luna, and by the way, the Luna is the name that was found by his mother and James's 2 sisters. James actually wanted to take the name Starfire, but the mother and the sisters went onto the internet, found the name Luna, and presented it to James, and that's what they chose, that his new name would be Luna. James is still a boy. Legally, he is a boy. Sex does not change. From the moment of conception, he was a male. He is an XY chromosome person. Referring to him as a her is an abuse of the language. However, this petition says that Luna is only known by her classmates as a girl. So it's a fraud, but that's the way that the classmates know James, not as a boy, but as a girl. In the order, In the order, the petitioner/mother was given the exclusive right, after notifying the father, to consent to psychiatric and psychological treatment of the children. And by the way, this is a joint managing conservatorship. Both parents have joint managing conservatorship over the children, and yet in this order, the mother is given the exclusive right to psychiatric and psychological treatment of the children. It further states that the mother sought proper, now proper is an opinion when you find out who she went to, the mother sought proper psychological treatment for the child and kept the father fully informed. In response to Luna's choices, now Luna again is a fictional name, the father has engaged in increasingly aggressive behavior, including physical force toward the mother. Now, the interesting thing was, this is what is said in the pleadings here, that there was actually a day-long jury trial regarding a supposed assault assault charge that the mother filed against the father. After a day-long jury trial, the jury acquitted the father, found him not guilty. His actions are clearly intended to threaten and intimidate the mother. Further, the father has engaged in emotionally abusive behavior toward the child. As example only, haircutting and other non-affirming actions. So to listen to the experts the other day, they said if there is a child that has this type of a gender, possibly gender expansion, gender confusion, whatever, there are 3 ways to address the child. Number 1, you can absolutely force him or her to stop all the behavior. That's probably the old-fashioned way, the way that I would have been dealt with had I expressed such a behavior growing up. There is a second way. The second way is the watch and wait. You watch and you just wait. You don't do anything. You let it play out. And because this is a phenomenon that happens in children, usually by the time they reach adolescence, 90% of the children that go through this actually align their gender, and gender is a social construct, actually align their gender with their actual physical sex. And there is a third way, and this is called the affirmative way, social affirmation. Somehow you must affirm the child in his or her feelings. And what these experts were saying is by doing that, and by also causing a social transitioning, you are actually causing long-term damage to the child. Yes, you may give him or her some short-term relief, but the long-run implications are very disastrous. So much so that one of the experts called it an experiment, and even said that to be in an experiment like this, it should only be done in a clinical setting with great safeguards protecting the child. But this is the type of treatment that Rebecca Orr, and Rebecca Orr is the counselor from the Dallas Rainbow Counseling. And when you think about Dallas Rainbow, you might think, well, that almost sounds like a gay, lesbian, transgender sort of affiliation. And you would be absolutely right. So Rebecca Orr is recommending this as treatment. And this is the type of person that the mother sought out to be the counselor. She continues, due to the material and substantial changes of the circumstances, the petitioner requests the terms and conditions for access to or possession of the child to be modified to provide as follows. Number 1, child's choice expressed to the court. Once again, a 6-year-old child. She is requesting that the court order an interview of the child, Luna, parentheses James, and Jude, with family court services, and a report be provided to the court and parties. Number 2, the amicus attorney. Ordering the appointment of an amicus attorney to provide legal services necessary to assist the court in protecting the child's best interest. And once again, as I've said many times, best interest is never defined, it's only asserted. Best interest is whatever a person thinks it should mean. It is an opinion. There is no objective standard. There is no way that anybody can say this is the best interest of the child. It just is not known. But we get to throw the term around. Number 3, she is asking the court for an order regarding cutting hair, enjoining father from cutting the hair of the children. She is asking the court to order the father to no longer cut the children's hair, period. Can you imagine this? The court actually thinking that it has this authority, and actually you'll find out that it made such an order. The disgusting thing is, this is not an order that any married, intact family would accept. Somehow, because of a situation of divorce, often forced upon one person, the court now thinks, and the state now thinks, that it has to be the super parent. It has these powers to go in and to just start micromanaging families. In many cases, their decisions are destroying families and creating conflicts. And yet, this is what the courts do. I think this is discriminatory toward unmarried or divorced parents. And I do believe that there are federal statutes that say that you should not discriminate on the basis of marital status, and yet this is happening in our courts on a daily basis. Number 4, the possession psychological treatment of Luna and actions outside the home. She wants the court to enter orders requiring the father to affirm Luna and honor her choices both inside and outside the home. And here are the consequences if he does not do so. Number 1, limiting father's consecutive overnight possession of both children, both James and Jude, and or supervising father's possession if he fails to affirm Luna. So she is asking the court to order the father to affirm the child's gender expression, even though it is contrary to everything he believes, contrary to what his church teaches, contrary to the normal psychological development of a child. And she is asking the court to order this. Number 2, she is asking the court to enjoin non-affirming behavior. So the father should be enjoined from engaging in non-affirming behavior and or taking Luna outside the home as James, or allowing others to do so. Once again, the XY chromosome child, legally known as James, a biological male, she is asking the court to forbid him from calling him by his legal name and forbid him from taking him outside the home as a boy. Number 3, on school nights, modifying the father's possession on school nights when there are school-related activities that may occur during the father's possession. She is concerned that the father may take the son, James, to the school as a boy where she has already enrolled him as a girl, and that people know James as a girl and calls James Luna. Now, with regard to the first mention here, limiting the father's consecutive overnight possession. In Texas, you have these different orders, a standard protection order, and somehow some counselor determined that the standard possession order was in the best interest of the child. Once again, the best interest of the child is this elusive nonsense term that means nothing, but as long as we say the best interest of the child, we're supposed to worship this order. So because he has a standard possession order, there are times he has the children overnights for maybe 15 to 30 days in the summer. And what she was requesting is that after every 3 days, the children get returned back to her so that she can help them emotionally adjust and affirm them again. Because, of course, the father is going to be abusive in such a situation. This almost sounds like it's a cult of transgenderism, a cult of LGBTQ. I know that if you have children caught up in a cult, the first thing you want to do is get them away from the cult. And with a cult of transgenderism, the cult of the sexual politics today, which affirms the homosexual and lesbian and transgender and pedophile lifestyles, all sorts of lifestyles, the father is just supposed to affirm that. And the court is supposed to make sure that he affirms it. The next provision is this. The next order, I should say, is this. Educational classes and counseling. Ordering the father to attend counseling and or educational classes associated with being the parent of a transgender child or a potentially transgender child. Why doesn't the court just give this order to every single family in the state of Texas? Married, unmarried, every single one of you needs to attend a class because your child if not transgender now, potentially may be transgender, you all must go to an educational class and a counseling class. And by the way, as per the orders, the recommendation of Dr. L. Britton, who was the child custody evaluator, for 2 years. Now, Dr. L. Britton came in after the time of this order, but eventually his recommendation is that Mr. Younger attend this class for 2 years. 2 years. He needs to have educational, and I believe it's also individual psychotherapy. Specifically, a class that educates the father how his actions and non-affirming behavior could be harmful to the child's emotional and well-being. So I will stop this video here and we'll continue it in the next video. Thank you.